And hopefully there's something of value that you all will take away from our lecture today. Anyway, questions. I'm fine jumping in, but as I understand from Hilda, there's a number of folks on today, so that might not be manageable. So what I'm thinking, Hilda, and please give me your feedback, is if you guys want to text to Hilda or someone who Hilda designates directly using the direct message feature your questions, and then she can parse out the same and ask me them directly as though she's acting as moderator, essentially. So she'll take your questions, kind of filter out duplicates, and then pose the questions to me. And then I will, Hilda, take breaks throughout the presentation to allow that to happen. And then at the end, of course, I think we're going to have plenty of time today because we've got a 2-hour slot. At the end, we'll save a bunch of time for just an open Q&A session on whatever topics, be they new laws, old laws, or new ways of applying old laws, as it may be. So with that, I'm ready to jump into it, whatever you guys are. Hilda, does that work for you?
That'll be perfect. And we'll go ahead and use the chat feature. So if anybody just wants to put a question in chat, then that'll give Bob and I an opportunity to filter through them. And then we'd be happy to pass those questions on to you when the time is allocated. So thank you very much, Adam. And thank you to all our guests. Let's rock and roll.
Great. I'm going to go ahead and share my screen. I have some slides I've made for today. I will make these available. I'll email Hilda the slides after the presentation, and she can distribute them to whoever wants a copy, or you can email me directly at Adam, ADAM, @brewerfirm.com. That's BREWERFIRM.com. And I'll get you the slides. So with that, let me go ahead and fire this up. I've gotten much better at this since our last virtual meeting because this is apparently all we do now. And so I will take a moment to remark on the fact that here we are in January and we're meeting virtually again. So good news is I think we're all better at it and we're comfortable with it. I guess the bad news or just news is that here we are, right? And without any, hopefully there's an end in sight, but without any major change. So anyway, let me do the screen sharing. Let's see here. Okay. All right. Hilda, can you confirm for me that you guys are all seeing my slides okay?
You're in good shape. We're ready to go. Thank you.
Oh, okay. Thank you very much. So today's presentation is a year in review and what's new in 2021. There's a lot of new stuff out there, as always, and then there was a lot of new stuff last year that frankly is still very new, both because the courts were closed for a good portion of the year, and so the law didn't have a chance to mature in any real way over the course of 2020, as it normally does. Very few appellate decisions issued and very few real estate appellate decisions issued in comparison with normal years. So, there's a lot going on. So I've tried to kind of go back and touch on some of the stuff that we've touched on before and how it's carrying over into this new year. As well as looking at the stuff that's being put into place this year as brand new law. So the standard disclaimer, if you've seen me speak before, you know that I put this up. This is our in-house legal department makes me put this in here so that we don't get ourselves in trouble. But in any event, bottom line is if you guys have a specific real estate question or legal question, important that you get specific advice because just a small change in facts and circumstances can drastically alter the outcome. But I know you guys all know that. So starting from the top, right? Statewide shelter in place remains in effect for all businesses. I wanted to lead with this slide again as a kind of reminder that, hey, we're still in this thing, right? COVID-19 is still there, it's still real, and in many ways it is still the biggest factor influencing the way we do business today. And so it's not something to forget about. We've got some comfortability with it now. We've sort of gotten used to, doing things differently, but it's important that we always keep up our guard and make sure that we're running our businesses in a way that's compliant with the law and that keeps people safe. And I think that's the important takeaway here from this slide is that, we're all business people here, and we all may have our opinions about the pandemic and ways to respond to it, and so on and so forth. And there's a lot of politics involved when we talk about COVID-19. But really, as business people, we should keep our focus on, okay, what does the law say? Agree or disagree, it really just doesn't matter. We've got a job to do, and it's not worth bogging ourselves down in the politics of COVID-19 when we're trying to run a business. Let's just know what the law is, let's comply with it, and let's move forward and do what we do, which is get out there and do business. So just a few takeaways from that. Businesses must continue to require workers to work from home whenever possible. So telework is still the norm. This is something you may not know if you run your own business, and this arguably includes those of you who have big teams of folks out there. You need to work with your broker and make sure that there's a revised social distancing protocol in place that has been filed with the county through the county's website. All businesses and entities are required to report to the public health department if they find that any of their workers have tested positive for COVID-19. This is a big one. It may seem kind of draconian, but it is a requirement for operation currently. So if you've got folks who work for you and they've tested positive, you need to make sure you're doing the appropriate reporting and appropriate response to that positive test. Capacity limitations, not so much a big deal here in the real estate industry. A lot of stuff occurs off site, so not a lot to know there. But if you are running an office, and for example, I know, of course, Hilda's got the main office there, and then also I know a lot of other folks who run teams and other things like that may have their own offices as well. And so it's important to understand what those are. There's a lot of different things you need to know. I put a link here. Again, I'll send these slides out so you can get the link yourself, but it's a great PDF file put out by the state, and it trots through all the requirements for running your real estate business. How do you report? What are your capacity limitations? How do you submit the social distancing protocol? All that stuff that you need to know in order to be in compliance with the current order. And it'll be in there. Now, the current order is still in effect, and given the numbers in intensive care right now, I don't see it being rescinded soon. So we'll see where that goes. And then, as always with these COVID things, it's completely in flux, and certain controls may be relaxed while others are tightened, and vice versa. So just important to keep on that. And this link here for the PDF will give you a good piece of guidance. And then that website from where that file comes is the state of California's COVID website, which I'm sure you guys are probably familiar with already. And that talks a lot about what you need to be doing if you're in business during this unique time period. So I'm going to go through a couple more slides that are kind of COVID related, and so that kind of deal with best practices, and then I'll take a break and stop the screen share and field any questions on this specific topic before I move into the next one. So new forms and rules related to COVID still are the order of the day and are likely to persist for some time. We've covered a lot of these forms in our other talks, and I know you guys have had some time to get familiar with them, so I won't spend too long on them. If you have questions, you can ask me. But you've got to have, again, office policies and reopening procedures, masking requirements, hand sanitizer, all that good stuff has got to be in place if you're going to reopen your office and have folks who are not telecommuting, who are coming in physically. We have some physical office staff at this time, and we're no exception to the rule. We've put in place our own systems and so on and so forth. I think most of you are aware of the modified procedures for showing property. That PDF file I linked you to will give you the most updated version of what the state of California thinks that you should be doing, but it's basically all the stuff we already know, which is keep the numbers down, keep the airflow up, get the windows and doors open, have sanitizer available, have sanitizing wipes available, cleaning high traffic areas in and out, cleaning the keys, wiping down the lockbox, anything that's got high touch points, in between showings, you're going to be hitting those. Of course, no open homes still is the order of the day. And then you've got your new forms that are related to, listing and sale of property. So you've got the coronavirus addendum, that's both for the purchase contract, and then you've got the updated listing agreement that CAR's put out, the property entry advisory form. I hope you guys are using that. It's super important to make sure that your buyers and your sellers know what the risks are. I think everybody knows at this point. I mean, I think it would be really hard to argue that you don't know what the risks of COVID-19 are, but in any event, you should be using those documents so that you have that in your file. And then as far as the property entry form, as I'm sure most of you know, there are different forms for the listing side, the buyer side, and so on. Also wanted to draw your attention to the CAR form mandatory and best practices as form BPPP. It is not a transaction document, but it's in the library and it's there for your information and for your client's information. So take a look at that, distribute it, make sure people are aware of it. And then of course, you're going to be posting these procedures at the property for those properties that you're showing. And that's again, a requirement of the state operation guidelines, which again, you'll find in that PDF form that I linked on the previous slide. So just sort of a reminder, you got to keep up on these things. You don't want people getting sick. There are already lawsuits bubbling up out there where you've got employment-related COVID claims, people claiming that their employer didn't follow procedures and it caused them to get sick. I'm sure you're going to be seeing it from clients, and I'm sure it's going to come from sellers, maybe even from tenants of properties that you're listing for sale. So it's really important that you have documented procedures that you follow, because that is going to be your best defense. I'll say when these lawsuits come, because they're already coming. It's not an if. And the if is whether or not you end up, becoming a victim to one of these suits, as the lawyers on the plaintiff side try to test the limits of legal liability for COVID illness. I think personally it's an uphill battle to make a claim, because it's very difficult to identify how and where one got sick. But again, you got to have these procedures in place. And just as one example, California's workers' comp law was updated this year to create a presumption that someone's COVID-19 illness is work-related for purposes of workers' comp under certain circumstances. I won't go into the details on what those circumstances are here. It's a little bit outside the scope of our chat today, but it's an example that, even the legislature is now deciding that, okay, if you've got folks working under certain conditions, if they get COVID-19, that doesn't necessarily mean tort liability for you, but it may mean that you've got a workers' compensation liability for that COVID illness. And it's presumed, legally speaking, that the illness was obtained or the person was infected while in the workplace. So definitely important reminder to keep up on those procedures. The next area I was going to dip into was the landlord-tenant stuff, because that has tended to be one of the areas of biggest activity both last year and now moving into this year. But before I do that, I will, as promised, pause briefly and turn to Hilda for questions on that.
Okay, I don't see anything in the chat at the moment in terms of what you previously covered, but I have a general question myself. So this is all purely on the honor system, right? If someone who is an independent contractor or an employee of one of our franchises comes in contact with the contagion or becomes ill, it is their responsibility to notify us, and then our responsibility would be to notify the CDC or the county or whoever we're obligated to do. If those parties do not notify us, we're under no obligation because we can't go on rumor or hearsay, correct? Because occasionally
Right.
we'll hear, gee, so-and-so is ill, but again, so-and-so hasn't communicated that to us.
Right.
Can I ask
That's right.
a question in addition to that, Hilda?
Sure.
So say somebody tells the office that they have COVID-19. Is it the responsibility of the office to let everybody know? They don't have to name a name, but is it the responsibility of our office to immediately notify us all via email or text that somebody in the office has tested positive? And if that is the case, are we doing that?
Adam, do you want to start?
Yeah, so that's a big question. So I'll start with Hilda's question, and then I'll go to your question.
Thanks.
And so, yeah, Hilda, you're correct. I mean, if nobody knows about it, then obviously it's difficult to report it, and how are you going to do it? Now, it's not as simple as saying, okay, if nobody tells me I don't have to do anything. The law is not totally clear on it. The law says that if you know, yeah, you've got to make the report. That's the requirement of being open. But the law also says in rather vague terms that, you've kind of got to have a procedure in place for people to notify you. Now, what is that? My assumption would be that it's as simple as, hey, if you, call this number, if you've got to report something, or if you've got to report a positive test result or something like that, right? I mean, I don't think it has to be, some sort of crazy scheme by which you go out and actively investigate whether or not folks are getting tested, and if so, what the results are. In fact, I think that might be kind of invasive the other way. So you have to have an open line of communication, but no, I would agree with you, Hilda, that it's not, investigating folks, like, oh, I saw Stan had a cough the other day, I'm going to go, give him a phone call and make sure that he's, nothing like that currently anyway. So, and then to turn to the next question, I believe, and I'm going to have to punt a little bit on this one because this is stepping a little bit outside of my practice area and more into the employment law sphere. But I believe there is some regulation about information sharing with respect to possible workplace exposure. So I think there is some level of that, but I think it's also very circumstantial, and it has to do with the type of workplace environment and and so on, and so how the report was made and so on. So I just can't, I don't know enough about that aspect of it to give a good answer, because that's really getting into workplace management, which is a little bit not within my ilk as a real estate attorney. So I'd certainly be more than happy to do some research with you and see if we can get up a good answer, or refer you to somebody who practices employment solely, because I think that's a pretty, at the end of the day, my sense of it is that's a pretty complex question. Sorry for not giving you a good answer.
Adam, we've had the challenge of course, the HIPAA concerns, right? And protect people's privacy with mixed with trying to manage this contagion. So we've been erring on the side of caution, and basically, if there's been any exposures that we're aware of in the market center, then we just close down, clamp down, re-sanitize, let people know without disclosing too much information or giving out any names, and treating it that way. So we're trying to manage that 14-day period. But
right.
It's a challenge. Some people are comfortable sharing what their experience has been through COVID, and others who are very private people and aren't comfortable or are still trying to heal or get well. And so there's challenges. But we did have an experience with one agent who went through it, had a bad case, and then became very public about it, and shared the story on Facebook, and then went ahead and did a care campaign and gave out vitamins and health remedies to others who are going through the same thing. So just, people are all in different directions on this subject. But what we really need to know is the legal requirement. We want to make sure we're always following the legal requirement. So if you learn anything more, please let us know. We will adhere at this level.
Absolutely, yeah. And I think the important takeaway for today's talk, the real estate, I think, focused element of it is understanding these protocols and procedures as they pertain to your practice of real estate, right? Because that's going to be on a day-to-day basis what's most important to you all collectively, you all agents and broker associates and whatnot. That's going to be your, where you're going to have contact with these issues day to day. And that's what that PDF that I linked to is great for. It really synthesizes, I think, very well what the state is expecting of you. And again, it's about number one, being safe, right? It's about being safe as best as we know how. And number two, it's about making your clients feel safe as best you can. And then number three, it's about having, again, a documented procedure saying, hey, this is what I do. I post this thing on every property I show. I get the windows open 15 minutes before I have the client in there. I leave them open 15 minutes after. I sanitize. And you can document all that. It's going to be very difficult to assail your practices if you've got a documented history of doing it. And that's where the CAR forms come in handy, especially the PEAD, where you can have people sign that so you know that you have a document that reflects that conversation with the client, right? So that's really where it's going to tie in from a legal standpoint on your day-to-day. So make sure that you are doing that stuff and don't, it's easy to relax, right? We all want to relax, but it's just a reminder, we're not there yet. We're getting close, so hopefully, knock on wood, but we're not there yet.
And Adam, can you just go over the county or the local jurisdiction even supersedes Cal OSHA or the state guidance on this. You know, if it looks like an open house, if it if it smells like an open house and there's, a line of people outside the driveway 6
Mhm.
feet apart or not, even if there's an open house sign that says by appointment only, people like to push the limits at times. And I know that there've been a lot of cases reported in Southern California, but Santa Clara County, is in the highest tier, and we
Sure.
really are trying to follow the letter of the law. So can you just
Yeah.
shed a little bit of light on that?
Absolutely. So the state, generally speaking, the state protocols are going to be what control. Now, in this area of the law, as in with most area of the laws, generally speaking, the more stringent measures control. So if Santa Clara County, for example, enacts something that's more stringent than the state as a whole, that particular element of the county scheme will be what controls, and then the other state elements will fill in all those gaps. So it's sort of if you think about it, it's the strictest regulations bubble up. So if you've got two county regulations, one strong, one weak, in comparison to the state regulations, the strong one's going to trump the state regulations, and the state ones are going to dominate the county ones where the county is weaker. So the law is always going to rise up to the most stringent level of protection. So that's where you need to look at this point. In my looking at it, the county of Santa Clara is roughly, if not entirely, consistent with the state of California at this point. And with this most recent SIP order that I want to say December 3rd was when it was voted on, or when the governor issued it. It's pretty uniform compared to last time. I think we were talking, it was during the first wave, and all the counties were firing off different ordinances left and right. A lot of it has normalized at this point, including in the area we're about to jump into, which is the landlord tenant stuff. There's been a lot of standardization now on the state level, because the state government has finally kind of gotten it together and made some more comprehensive procedures for these things. So as I know it, Santa Clara County and the state are roughly on the same page, but if there is a regulation that's more stringent, be it from the state or the county, you're going to apply the more stringent one. And yeah, you're right, Hilda. Creative thinking is fun, but creative thinking in the law is usually a bad idea, right? Do what the ordinance says, and don't get creative. I have an example. Way back when, for a very short period of time, when I first got out of law school, I did an internship with an employment law firm, and we did wage and hour stuff. So it was overtime, minimum wage, and a ton of employers would pay their folks salaries in an effort to avoid those laws. You can do that. That's a legally permissible thing to do under very specific circumstances. But these were companies like, a cleaning company, and they were paying their janitors, on a salary, and the salary equivalent, when you compared it to their hours, ended up being like maybe $3 or $4 an hour, which was, less than half the minimum wage at the time. And we would sue those folks, and the response we would almost get from the employer was, well, I'm not responsible. I paid them on a salary. I don't pay them hourly. And it's kind of like, did you think that was like, that you were the smartest person in the room, and you could get away with paying somebody $3 an hour when the minimum wage is 10, just because you called it a salary? I mean, common sense dictates that that's probably not going to be a viable legal argument, right? But folks do stuff like that all the time. And I think that's kind of where you're aiming at, Hilda, a little bit with the open houses. It's like, look, if open houses are prohibited, don't have folks line up in front of the house 6 feet apart to come to their appointments as they tour the home. I mean, it's gonna, if it looks like a duck and it quacks like a duck, it's a duck. Don't do it. So just stick to, the letter of the law, and make appointments, and don't do open houses, and find other ways to move the property. And it's moving. So the movers and shakers who I know are still moving and still shaking. So those folks who are dedicated are figuring out a way to operate safely and in accord with the law.
Perfect.
All right.
Thank you. One last question on this
Sure.
topic in regards to the PED. If an agent is meeting with a client for the first time, they sign. Oh, we had some feedback there. Sorry. So someone would sign a PED to enter the property or conduct a listing presentation. They sign the basic same health declaration as buyers do.
Mhm.
Okay, good. I just
Right.
want to confirm that. Yeah.
Right. Yep.
Perfect. All right.
Yeah,
please.
and there's several different iterations of the PEDS forms in zip forms too, for the varying different circumstances that you might use it. I want to say there's like 4 or 5 different PEDS forms. They're all very, very similar, but you can pick the one that's most appropriate for your situation.
Perfect. Thank you. Okay, let's go on to any forms and updates to contracts and other things like that. Thank you.
All right, so I wanted the next stop. We'll move from business practices and we'll call.
Before we leave that subject, can I ask a form question of the PEAD question?
Go ahead, Leanna.
I think he's frozen. When you have a listing, you get like 20, 34 PED forms, right? For showings. Do we have to have the seller sign all of them or just the one that would get into contract? So what do we do with that?
I'm sorry, my internet broke up for a second. I don't know if I was coming through or not. I had dove into landlord-tenant law, and then when it came back, I heard the tail end of your question. So you're either going to need to ask me again, or we can circle back at the end. Or
I know your video froze for a minute.
Okay.
We get the PED. When I have a listing, I get 20, 30 PED forms from buyers who are showing the home, right? Buyer's agent showing. Do we have to have the seller sign all of them, every single one that we get, or just the one that we got into contract with?
I don't think that the seller needs to sign every single PED form, so long as they sign the forms that are relevant to the listing, and then have them sign the one that particular buyer signed. It's more important that the buyer gets them and signs them. That's really the target audience of that form, right? Is you want to have the seller advise think about it this way, right? When we do a listing, what's important? It's important that the seller know and understand the risks in showing the property. So we take care of that up front. And then with each buyer, we want to make sure each buyer, we have documentation that they were made aware of the risks of seeing the property. So I don't think it's necessary to have the seller sign every single buyer PEAD form that comes across the table. But I do think it's a good idea to have them sign the one that's attached to the contract, assuming they get a deal. Yeah.
Wonderful. Thank you.
Mm-hmm. And then I saw a note somebody typed out, all vendors should sign PEDS. That's also true, right? That's also a good practice, of course. All right, so jumping into that, I'm going to share my screen again and go through a couple more slides, and then I'll click back on for questions. Let me see here. All right. Okay, so the COVID-19 Tenant Protection Act of 2020. I'm not sure if this had been enacted yet when we last saw each other. It came out in about August of this last year, and it was meant to address the lack of uniformity on the county-to-county level as far as tenant protections, and then also create a stronger, again, more uniform statewide system to replace it. If you recall, back at the beginning, the California courts had actually shut down evictions almost without exception. And so the courts, the Judicial Council was not allowing any unlawful detainers or evictions to proceed. And they got a lot of heat for doing that. You probably read some articles about that, whether or not it was within their authority or not. But before that could sort of boil over, the legislature stepped in and finally enacted something more comprehensive on the statewide basis to kind of resolve those issues. And then at that point, the Judicial Council rescinded their moratorium on eviction. So what came out was this COVID-19 Tenant Protection Act of 2020, also known as AB 3088. And it creates kind of an interesting system for dealing with non-payment of rent during this COVID time. So the protected period starts in March of 2020, right? And then runs through the end of this month. And then you'll see I put in parentheses for now, right? Because almost every type of COVID protection that we've seen roll out since the beginning of the pandemic has been extended in some way, shape, or form. Some of those protections have gone away now, but some have not. So I'm going to say for now, I wouldn't be surprised at all if this gets extended or modified to go beyond the end of January. And it creates 2 periods of time which are protected in terms of payment of rent and specifically eviction for the non-payment of rent. So you have from March 1 up through September 1, and then September 1 up through the end of January. And again, I've put in my quotes or parentheses for now, right? Because I would not be surprised if there's not a longer period tacked onto this. And what that means is a tenant cannot be evicted for the non-payment of rent between March 1 and September 1. So any rent that was not paid during that time period cannot serve as a basis for eviction. Same is true for September 1 through the end of this month, January, with the slight modification that the tenant has to pay 25% of the rent. So long as they pay 25% of the rent for that period, September 1 through January 31, they are protected from eviction. They cannot be evicted for any rent paid so long as they pay 25% for that period. And then they have up until the end of this month to do it. So it could be that they've paid none of it at this point. So long as they submit it by the end of this month, they are protected by this statute. Now, there are some procedures for implementing that, and there are some forms that the CAR has put out that help implement these procedures. And basically, the way it works is the 3-day pay or quit notice that most of you have heard of before for non-payment of rent has been done away with for now. It's been replaced with a 15-day pay or quit notice. If you look at the bullet point that I have here on the slide, that's this notice here, the PRQ-CCP. And that's a 15-day pay or quit notice. And it comes along with this document here, which is the notice of the COVID-19 Tenant Relief Act. And it comes along with this document here, which is a tenant declaration form, right? So those are your 3 documents that we're talking about when we deal with non-payment of rent. So what happens now under the new law, AB 3088, if a tenant is not paying rent during these protected time periods, you can still serve a notice to pay rent or quit. And so long as it's going along with these other related documents, they have to come as a package. And the tenant then has those 15 days to either pay the rent or return this declaration here, this tenant declaration, DCFD. And that's a declaration form that the tenant signs under oath that says, hey, I've been financially impacted by COVID-19. And so long as they do that, they're entitled to the protections that are offered to them for this protected period. They don't have to document it. They don't have to prove it. All they have to do is sign the declaration and return it. There's one small exception for high net worth tenants, tenants whose income exceeds $100,000. And those tenants can be required to document their financial impact, but the law is not entirely clear as to how that happens, nor is it entirely clear as to how I know this person is high net worth. I've just been telling people, look, if they've applied and in their rental application materials, they indicate that they have an income that's above this threshold, then that should be sufficient for you to then be able to demand some documentation under the new law. But it is very difficult to do because, you know, if you don't have documentation of their income to start with, you know, the baseline in the law is that all they need to do is return the declaration. So prudence dictates that, you know, we've got to be careful with what we ask the tenant for in terms of documenting their income impact from COVID-19. And certainly if the application materials for that particular tenant show an income that's below that threshold, then the declaration alone is going to suffice and it sort of stops there. Good thing, I guess, is that period is up soon. It only runs through the end of January, and then the tenant has to resume paying rent as normal after the end of January, at least for now. You know, the regular 3-day pay or quit notice is going to come back. And then what happens to all the unpaid rent is that it's still owed by the tenant. It just turns into a consumer debt, much like credit card debt or anything else. But the landlord can go to small claims and recover it as of March 1st, and that's regardless of amount. So this is sort of something that the landlords were given in this legislation, which is that they can avail themselves of the much quicker, cheaper, and easier process of small claims court to get a judgment for that unpaid rent starting March 1st, and it's regardless of amount. Right now, the limit for small claims court is $10,000, but because of AB 3088, if you're going for unpaid rent that was unpaid during this time period, it doesn't matter. It could be $15,000, it could be $25,000, doesn't matter. You can still go to small claims court to collect it. So it makes it a lot easier and a lot less expensive. So that's the scheme as to unpaid rent. The other major thing that AB 3088 did was, if you recall, at the beginning of the year, we were talking about the big new news, and this was before the pandemic hit, of the Tenant Protection Act, or the statewide just cause and rent cap laws. Those just cause protections under the Tenant Protection Act, which is AB 1482, are extended to all residential landlords. So even those folks who would be exempt from that state law, which went into effect in January 1 of 2020, even if you would be exempt normally, you're no longer exempt, at least through February 1. And as I said, for now, would not be surprised if that gets extended beyond that. And what that means is basically that you cannot evict a tenant, setting aside for the moment non-payment of rent. You can't evict a tenant for other reasons, including the termination, for example, of a month-to-month tenancy on a 30 or 60-day notice until February 1. So it's just something to keep in mind. And again, we're talking about these dates, at the end of the month now, but I would not count on it being the end. I don't see the numbers changing. I don't see the political will changing. I would be actually more surprised if it does not get extended, but maybe I'll be wrong. We'll see. But I think extension is going to be almost certain at this point, at least in some fashion. One exemption is left, and that's if you're selling a single family property and it's under contract and the buyer is going to use it as their primary residence, then the tenant can be evicted, and that is permissible even under this new stringent AB 3088 in combination with the prior Tenant Protection Act, AB 1482. All right, so the next slide is Tenant Protection Act of 2020. I just included this in here because, as I was just explaining, the new law from the end of last year, which is now carrying over into this year, was in part based on this Tenant Protection Act of 2020. So don't forget about this, right? This is something that we talked a lot about at the very beginning of last year, and then we kind of got swept away by the pandemic, and that took over the conversation. But don't forget about this law. It's still out there, and it still applies to many properties. And so I put here a little brief review. Okay, so statewide just cause eviction control and rent control. There's exemptions for single family properties, so long as they're not owned by a corporation or a real estate investment trust, with mandatory notice to the tenant. I've been seeing this a lot in practice lately. A lot of landlords coming in, and I've got to walk them through how these two laws, the Tenant Protection Act of 2020 plus the newer AB 3088, affect their ability to do what they want to do with their property. And a lot of them don't understand this Tenant Protection Act of 2020, and importantly, don't understand that there's got to be a mandatory notice to the tenant. So it should have gone out already. For those existing tenants, they should have gotten notice by August of 2020. And then for new tenants, it's got to be in the lease agreement. The CAR has already updated the forms. So the new CAR lease agreement has this information in there, and there's an addendum that includes all the necessary statutory language to satisfy this notice requirement. So you don't need to worry about necessarily what to put in that notice. You just use your CAR forms. But it does need to be, as of now, part of every new lease you sign. Now, I got this question in my office the other day. A gentleman had somebody on a fixed term lease that ran from, I want to say, May 2020 to May 2021. They did not mail the notice by August. And they hadn't mailed it at all. They first came to see me, I think it was probably in November of last year. And so they had missed that deadline. But yet this tenant was on a year lease up through May. So they weren't going to renew the lease up through May. So what was my advice? Well, my advice was mail the notice anyway, but it's probably not effective, right? It's probably not effective because it went out late. And so the net for that particular individual, my opinion was, and remains, that they've probably lost that exemption at least through the end of this lease and until they renew with a new lease that includes the required notice. So be wary of that. I mean, you may have a lot of clients out there who think that they are exempt from this 2020 law, but they didn't meet the August notice requirement, and so they may have lost that exemption already. And so it's super important that they mail it out right away and make sure that it's in the new lease. And they still may need to be careful about whether or not they've lost, at least for a few months, that exemption they would otherwise be entitled to. It's a bit of a moot point now because if you recall the last slide, these exemptions have been at least mostly eliminated by AB 3088 up through February of this year. So it's sort of a moot point on some level, but again, something to be aware of that I've seen people have missed this. I've seen a lot of folks come in the door who were unaware of this requirement. The rent cap has been a source of concern and confusion for a lot of people. Just a personal anecdote for myself, I had a family member who rents an apartment and they got a rental increase notice, and it exceeded the amount currently allowed by state law. It was an apartment in a very large apartment complex, hundreds of units, managed by a professional management company and owned by a huge investment company. So there's no question that the law applied to these units, and this management company had distributed notices to my family members to increase their rent in an amount that was plainly not allowed by the law. And so, think about that. I mean, this company is a professional management company, and they manage properties nationwide, and they missed this, right? They clearly missed this. And so I wrote some letters, and eventually their attorney basically conceded that they had screwed it up. But it's again, if folks who are operating on a national level are missing it, I imagine that there's lots of other people missing it. It's currently about 6% max in a 12-month period. That's a moving 12-month window. It's not a calendar year, so you got to look 12 months back and total up all the rent increases in that 12-month period and make sure you don't exceed the limit. And then it's changed every year depending on the rate of inflation. So maybe the year before it was higher, around 7 or I think 8%. Now it's down 6%. What's allowable? So it's 5% plus the CPI. There's been some changes to the law over the course of this calendar year, over the summer, that clarify how that CPI is calculated. It's pretty complicated, so I won't get into it today. But if you want the formula, you can email me and I'll send you out some tips how you calculate exactly the maximum allowable percentage. And then, of course, evictions are allowed only for enumerated just causes, which is a huge change in the law. And a couple of things that I've been seeing over this calendar year as this law has made its debut. Just a couple of observations. Number one, expiry of a fixed term lease is not just cause. And this is another source of confusion for both professional management companies and what I'll refer to as mom and pop landlords. I've advised both on this issue, and it's definitely something that people don't understand. It used to be under the law when if you're subject to the law, of course, if you're not exempt, normally when a fixed term lease expires, you could just evict the tenant. There's no notice required, right? That was California law prior to this act of 2020. However, that's not the case now. You can only evict somebody if it's one of the enumerated just causes, and the expiry of a lease is not a just cause. If the tenant refuses to sign a substantially similar lease, that can be a just cause, but the expiry of the lease itself is not. So, query what the importance of that fixed term lease is under this new law. You can't say, hey, look, your lease is up in January, I want you out of there. That's not a just cause. If the law applies to you, if you're not exempt, you cannot evict them for that reason. So that's a huge change in the law, and I don't think a lot of folks really understand that and the impact of And then related question is the 60 or 30-day notice a thing of the past? A lot of people like to rent to folks month to month because they can terminate that lease on a 30 or 60-day notice, depending on how long the tenant has been there. But again, if the law applies to you, if you're not exempt, there is no such thing essentially as a general 30 or 60-day notice. Every notice has to spell out specifically the just cause that the landlord is relying upon under the act in order to do the eviction. So they're gone are the days where you could simply give a tenant a 60-day notice, for example, and say, hey, I'm terminating your lease. Sorry, you know, and that was the law before. You could do that. Now that's not a permissible basis for eviction anymore. So I think those are probably the two biggest things that I've seen in my office is folks coming in with confusion about that, or having done that, you know, they'll give a 60-day notice to the tenant and then they'll get a letter from a tenant's rights attorney saying not so fast. And I have the misfortune of telling them that they're probably correct and that they cannot use that as a way to evict the tenant. So that is my landlord tenant review. I'm going to stop the share again, and then I'll go and dip into a kind of brief overview of some of the new laws that I thought you all would be interested in. So any questions on the current status of kind of COVID rent or landlord tenant stuff to do with COVID? I see Mark has a hand up.
Thanks, Adam. Thank you for coming today. Adam, quick question. You said that they have to have just cause. Is if a landlord is looking to move into the unit, is that just cause?
Yes, that is just cause. I will put a sort of warning flag on what I'll call, typically referred to as owner move-in evictions, right? So an owner move-in eviction is just cause. It can even be certain members of the owner's family, and that will apply. And so that is a legitimate basis. Now, there is a relocation expense associated with that. I believe off the top of my head, it's 1 month's rent under the Tenant Protection Act of 2020. So it's not, you do have to pay some money in order to make that happen. You can't just move in. And I believe there's a requirement of a 1-year residency requirement. I'll have to double check that because they vary from jurisdiction to jurisdiction. For example, in East Palo Alto and San Francisco, it's 2 years that the owner has to live in there. And I actually defended a client once who did an owner move in, and what happened basically is she did an owner move in eviction. She moved into the property, and then there was some question about whether or not she was actually living there full time. And what had happened is the neighbors, bless their hearts, called their old friends, the tenants who had been evicted by the owner, and said, hey, we don't think this lady's living there. And so it kicked off a lawsuit. And under the East Palo Alto local ordinance, which is stricter than the state law, you know, there were all sorts of penalties and stuff that we had to then, you know, negotiate our way around and deal with. So it just to say, be careful with that. Make sure that you're adhering to the relocation payment requirement, number 1, and residency requirement, number 2. And again, what that is going to vary from city to city, you know, depending on whether or not they have local rent control. For example, San Francisco is like the worst for owner move-in evictions. They're very strict, and the relocation payments can be up to $40,000, depending on if the person's disabled or elderly, or if they have kids. It changes. So you need to know those local requirements.
Another quick question. If a landlord wanted to protect himself and remain in greater control, would they be able to put terms in a 12-month lease that would terminate the tenancy in exactly 12 months?
The answer to your question is, if the act applies to you, the answer is no. And that is because that is the way a fixed term lease always has operated. The law status quo, the law as of 2019 and going back, you know, years and years, if not hundreds of years, is, look, if you've got a fixed term lease, once that fixed term is up, it's over. No notice required. I don't have to give you a 30-day notice. I don't have to give you a 60-day notice. Most landlords do because they're nice and they just want to make sure that the tenant is aware that the lease is expiring and, like, you know, kind of, hey, I'm not going to renew your lease. You might want to make sure you're looking for something else, you know, but none of that's legally required. The law, at least before the act was implemented in 2020, was it's over when it's over. No notice required. That is completely undone now. If the act applies to you, that no longer exists. The only way you can get them out at the end of the fixed term is if there's some other basis, like an owner move-in, eviction or something like that, to remove them, or if they refuse to sign another substantially similar lease. So if you go to renew and they're like, well, I don't want to sign a written lease, I just want to go month to month, you could use that to evict them.
One more question just came up. If the if the landlord, let's say you acquire a property with a I was going to say, if you're acquiring a property that has a tenant already in place, or if you're listing a property that is currently tenant occupied, but the lease is going to expire, is removing them in order to sell the home to another party a valid reason to terminate a tenancy?
Is removing the tenant from the home to sell it to somebody
Well,
else a valid basis for eviction? Is that the question?
Yeah, let's say I've been leasing my home for 3 years to a tenant, and now I want to sell my home. And I know that selling a single family home with a tenant is not optimal for the seller. Would I be able to terminate the lease at the termination to remove that person in order to sell the home?
That's a good question. I actually had this question not that long ago. A client came in with a very similar question. My read of the law is that the answer is probably not, because the law requires it. So the current law does allow for an eviction to occur under the circumstances you've described, so long as the buyer is going to be the owner occupant of the property, right? So long as they're buying it to live in it. But logically speaking, how does one know that until one finds a buyer and verifies that buyer, or at least says they're going to be living there, right? So I don't think you can jump the gun on that. I think you've got to wait until the property is in contract in order to move forward. So that's my opinion on it. I suppose you could try to evict and say, well, I'm only going to sell it to somebody who's an owner occupant, but I don't see that argument being viable. I think it puts the cart before the horse, as they say.
So then basically we should be cashing for keys people to get them out then to terminate their
Correct.
tenancy. You can't.
Correct. Yeah. For lots of different reasons too. I mean, that also, grease the wheels a little bit and move on. I mean, I'm a big fan of a good, I'll say, put a pin in that, a good cash for keys agreement, because then everybody's happy, and it's usually a lot less expensive than picking a fight with somebody. Even if you're right and you win the fight itself is time consuming and expensive. So, I think if you can get an agreement, that's enormously better than the alternative.
I have a question.
Go ahead.
So what if you have a tenant and they're considered an essential worker and you don't get your rent?
Well, the same thing as I described in the first slide about AB 3088. Right now, nothing. You basically can't evict anybody for non-payment of rent as long as they're willing to sign that declaration saying that they've had some kind of financial impact from COVID-19. And financial impact is very broadly defined. So it could mean virtually anything. It could mean increased difficulty finding childcare, increased childcare expense, increased expenses in the form of PPE that they have to buy. I mean, it's basically any change in financial circumstances due to COVID-19. And you're not really allowed to inquire into it. So as long as they're willing to sign that declaration, you're stuck with it, right? You can't evict them for non-payment of rent. And in fact, if you try to, there's a fine that you'll get hit with if you do. So the fact that they're an essential worker, I don't see that as being decisive one way or the other. Or to put it somewhat differently, the law does not speak to a difference with regard to non-payment of rent between essential workers and others.
I have a question.
Thank you.
I have a question. If you provide them with a handwritten notice and not put it in the mail, and they acknowledge receiving it, and then you have the normal 12 months or 15 months, whenever is allowed in February, does that suffice for evidence of rent increase?
So the notice is to increase the rent. Is that what I hear you saying?
Correct.
Yeah. I mean, it's going to depend on the content of the notice, and if it has all the, I mean, the fact that it's handwritten doesn't necessarily mean
I mean,
anything.
it's not mailed, it's not certified, it's just delivered. And usually their rent would have been increased in November, which is their 12-month period, but because of COVID, it's now going to be February. So it's
So-
extended.
Yeah, I mean, you could still increase their rent as so long as you're in compliance with the rent cap,
right,
assuming that
compliance.
they'll apply to you. Yeah. And a handwritten notice is certainly just as enforceable as a typewritten notice. The
didn't-
fact that it was hand delivered, I don't think is a problem either. I mean, I typically would advise that you mail a copy if you're going to deliver one by hand. Mail a copy as well. That would be my general advice to you. But I think as long as they've got it and are aware of it, rent increase notices are more flexible than eviction notices, just generally speaking. So there's less formality required.
Thank you.
Okay, Adam, we're going to go ahead and move things along to the next topic. I think we could have brought you in for a total 2-hour session just to go over COVID, and especially everything that involves tenants.
Right.
That's another complete just can of worms. So we
Huge.
we may want to do that because we didn't, I had no idea there was so much to share in this space. And I think if we advertise it accordingly, we'd probably have just as large a group, if not larger. So let's plan
Right.
on something like that. Okay, so please let's go ahead and move along with the next topic.
Well, that's a perfect segue, Hilda. And you'll see by my next slide that I'm on the same page because the next slide is, so what's next? Okay, so I've tried to compile here over the next few slides. Each slide kind of covers one new law or group of new laws that kind of indicate, what's been done and what's being put into law this year that you should be aware about. But I also wanted to put this slide here to sort of kind of prompt some thinking or some conversation. Although what's next? What should we be looking for in the year to come, right? So a few things that I'm thinking about that I think you're going to see a lot of areas to be wary of, to keep your eye on over the next few months, next year, is continued changes in the landlord-tenant sector. As we just saw on my last few slides, there's a lot going on there. There's a lot of interest there. If you guys are interested in it like you are, I'm sure your clients are interested in it too. Especially if you deal in rental properties or even the purchase and sale of tenant occupied properties, lot to know there. So keep looking for changes there. There's going to be ongoing changes in that area, again, because the pandemic is still going on and it's a political hot button issue. So keep your eye on that sector. It's going to be changing. I predict more and more changes to the ADU laws and housing policy type considerations. So keep your eyes out for that kind of stuff. Affordable housing type laws, ADU construction laws. We're going to cover a couple of those new laws that are already coming out this year in the next few slides. Get ready for enduring and stringent health and safety protocols, right? I don't see those vanishing soon. Even as folks start getting the vaccine and things like that start happening, it's going to take a while for everybody for that process to kind of play itself out, and so expect that that's going to be going on for a while. Keep your eyes open for additional financial supports and incentives. I am forecasting that we're going to see more of this, and maybe there's going to be some opportunity out there for you folks to flag some of these supports and incentives for people, so that they can use those in order to maybe get themselves into a home, or you can work those incentives and supports into your marketing mix and show that you're an industry expert and help connect them with resources they need to buy a home, hopefully using your services. So I think that's a great way to engender yourself to your clients and potential clients, and it provides real value to them. So keep an eye out for those. Nothing specific to flag in that area. I mean, I have seen some communities offering certain things in other states. In particular, you've got communities that are trying to take advantage of people leaving places like California by $10,000 grants just to set up shop and to work remote from their particular state. So all sorts of things are going to be happening in that space, I think, as we start to come towards the other end of this pandemic and start to reopen and rebuild. Modified property tax rules. Property tax has been a hot button issue for a few years now. I mean, really ever since the 1970s with Proposition 13, but it certainly seems to be getting traction these days. And we've got Proposition 19 that just passed, which we'll cover in one of our slides coming up. But keep looking for more stuff as it relates to property tax. And then other real estate related protections. I'm hoping to see more protections for small landlords. There's a few that have been rolled out, but not very many in my opinion. So keep an eye on that kind of stuff, and maybe even some foreclosure protection and things like that coming out. Excuse me. And then of course, after a year like 2020, who knows, right? Who knows what's going to be happening? We have no idea what direction things are going to take. We've got a new president coming in, which always creates a certain amount of instability in all the different marketplaces. So who knows what we're going to see over the next few months. Keep your eyes open, pay attention, and being on top of these issues will allow you to be, again, like I said, a market leader. So I'm just going to kind of breeze through these as quickly as I can, and then we'll do Q&A, and we can come back and revisit any of them. They're not in any particular order. So this one, relax rental restrictions for homes and ADUs within a common interest development. That's just a fancy way, really, of saying an HOA. So what the law says is that HOAs now cannot create limits on the percentage of homes within the development that can be rentals that's any less than 25%. So it's got to be 25% or more, right? So an HOA, for example, can't say, oh, only 10% of the homes in this development can be rentals. That is no longer permissible under the law. It's got to be either 25% or higher, or no limit whatsoever. And then importantly, with respect to ADUs and what we call junior ADUs, which is basically the same thing, except the main difference being is that a junior ADU is attached to the main home. Think a converted garage, whereas an ADU is a freestanding unit that's usually built in the side yard or backyard of the existing property. Those cannot be accounted. They're not subject to the percentage limitations that the HOA may enact. So basically, HOAs cannot use these percentage limits to prevent homeowners who build ADUs and JADUs from renting them out. So that's kind of a big deal, in my opinion, because that was one of the ways, as I'm sure, again, you all know, there's been a lot of change in ADU law recently, and it's much, much easier to build one or even two ADUs on a piece of property than it ever was before. And, one could rent that out for a substantial amount of income. And now an HOA can't enact a limitation on that. You were seeing that happen a lot in sort of higher end communities where the HOA didn't want folks building these ADUs and then renting them out, as a way of, I think the idea being it would change the character of the neighborhood. So that's not going to fly anymore. Those units cannot be counted when assessing any limitation. And again, those limitations have to be at least 25% or more. Goes into effect as of the first of the year. Doesn't matter. It doesn't require that your HOA adopt any change to the governing documents. It's going to be automatic. So it's already happened. And so something to think about when you're helping folks look at properties that are located within an HOA or that may already have an existing ADU that they may consider renting out, right? So it's a good thing to know. And then if the HOA doesn't come into compliance with the law, they could be subject to a fine for non-compliance of $1,000. PACE liens, mandatory paper disclosure. This was actually a CAR-sponsored piece of legislation. I actually had to deal with one of these, in practice, and I understand why the disclosure is important, because my client at the time really didn't have an understanding of what this PACE loan/lien was, and bought a home that was subject to one of these things, and it was a relatively unwelcome surprise. And so what they are is they're loans typically for energy efficiency upgrades, although wildfire defense is also permissible. So something to know. They can be good. They're very low requirements for the borrower, no down payment, but they are basically assessed against the property like property taxes. They're charged as an assessment against the land on the tax bill, and and they take priority over all of the liens. This is where they get a little problematic. They're like a super lien. And so, you know, they dominate, and even if there's a mortgage on the property or whatever, these liens are going to be a higher status than those. So they're almost like the property taxes themselves. And so they're attractive to lenders. The problem for the borrower is they can kind of carry a high interest rate compared to what our market rates right now, you know, 6 to 8% compared to what are very low rates for, you know, a HELOC loan or other type of financing for home improvement, right? So they just may not be the best way. If you've got a borrower who's decently qualified, that, you know, it may not be the best way for them to finance these type of home upgrades. They do run with the home. So that means if I sell my home and it's got one of these PACE loans on it, that loan is going to transfer to the new buyer. So if you're representing a buyer and you see a PACE loan, make sure they understand that it's not going to get paid off necessarily as part of the sale, like a mortgage loan. And that was the exact issue that I was called in to deal with. Buyer bought a home. Everybody assumed that this PACE loan was going to get paid off, and it did not. And so there was a problem. Because they attached to the land itself, and so unless they're taken care of, they're gonna carry over to the new buyer. A lot of lenders require that they be paid off at this time of sale anyway. This is the other big issue, is that borrowers, when they take the loans out, don't really understand that they are going to have to pay these off potentially in the sale. And any loan that's guaranteed by Fannie or Freddie is going to require that the PACE lien get paid off in the transaction. They won't lend, they won't fund the sale unless that happens. So they've got to pay that loan off at the time of sale, which can be sort of rude awakening for the seller, right? Imagine a seller takes out a PACE loan thinking they're going to do some energy efficient repairs to increase the marketability of the property. A couple of years later, they go to sell, there's still a big balance on that loan. Now they're going to be getting a lot less equity out of the property, and they may not have done those repairs or upgrades if they had known they would have to pay it off, right? Because it may not have been financially a good decision, right? It may not have increased the value of the home as much as the debt amount. So make sure your borrowers and your buyers and everyone understands how those loans work. And then this new law just requires that a paper disclosure be made during the transaction. If there is a PACE loan, that the buyer sign a disclosure of it, and then it requires special disclosure at the time that the loan is made, which is probably less relevant to most of you unless you are involved in the making of these loans. All right, this is a big one, wildfire disclosure point of sale requirements. It's not a new law. It was a new law last year, actually, but it didn't really take effect until January 1 of this year. There's still certain parts of it that aren't going to take effect for another 5 years from now. But this is sort of the meatiest part of it. And it's got a disclosure requirement and then sort of a point of sale requirement. So from a disclosure standpoint, if the property is in a high or very high fire hazard area, there's a statutory disclosure language that needs to be included. And then the seller must also disclose known vulnerabilities. So if the seller has an awareness of certain conditions that make the home susceptible to fire, or for example, if they know that there's not enough defensible space around a certain part of the home, or whatever it may be, that's a disclosure. It's going to be kind of tricky because a lot of sellers may not know what those vulnerabilities are. Of course, it's only a disclosure issue if they know it, just like everything else in the world of disclosures, but it's something to be aware of. And something to review with your sellers if you are selling a property that is in a high or very high fire hazard area. And the second major component of the law is if you are a seller in, again, a high or very high hazard area, you have to provide the buyer with documentation saying, or showing, I should say, that the property is in compliance with local defensible space rules, or if there are no local rules, the state defensible space rules. And basically what that documentation is an inspection by some local government entity, fire marshal or whoever it may be, that says, okay, yeah, I've come out and I've inspected this property, and it complies with the local rules. Now, If there is no such documentation, and it has to be relatively recent, it's got to be an inspection that was done within 6 months of the date of sale. If there is no such documentation, that's okay. The transaction go forward, but the buyer and the seller must sign a written agreement that the buyer is going to obtain compliance with those defensible space rules, again, either local or state, within 1 year of the purchase, right? So that's the second component, is documentation of local compliance or state compliance, and if none, an agreement to come into compliance within 1 year. And it applies to all sales in which a TDS is required, which is most of the sales that you all are doing, with the same exemptions and exceptions to the TDS as already exist under current law. So it's just a new area of disclosure to be aware of, and make sure you're addressing that in all your transactions in, again, high or very high fire hazard areas. And if you don't know, you can look that information up. It's easily available online, and it also is going to be reflected by the by your JCP or property ID report, or whatever it may be, your NHD. So this is an interesting one, right? A first refusal on foreclosure sales. New law allows tenants of foreclosed properties, folks who are going to be owner occupants, community groups, and certain nonprofits, and the government, basically a right of first refusal following a foreclosure auction. A right of first refusal, if you've never heard of that before, it's basically a kind of last chance to buy, to the exception of everybody else, right? So if I have a contract that has a right of first refusal in it, I'm saying, okay, you can sell that house whenever you want, but you've got to come to me first and give me a chance to make the purchase, and to meet or beat basically whatever price that you're getting from the other potential buyer. And if I'm willing to do that, then I get the property and they don't. And so that's what's been done in foreclosure sales. Now, following a foreclosure sale, there's a time period where in one of these groups or one of these individuals has a right to make an offer that meets or exceeds the highest bid obtained in the foreclosure auction. And if they're willing to do that and able to do that, then they get the property, and the person who won the foreclosure auction does not. So it's an odd law. It was a law actually that CAR opposed. How it's going to be implemented, I think, remains somewhat to be seen. And so that was one of the concerns that CAR had when it was being enacted, is, you know, the expense and administrative overhead in rolling it out. So we'll see as the law matures how that gets done. But certainly something to be aware of, and perhaps even an opportunity for some of you who are working with buyers. It might be yet another stream of properties that you can look at to get them into something if they're having trouble, you know, finding properties on the regular market. Independent contractor status of appraisers and home inspectors. This is basically exactly what it sounds like. This has been true for real estate folks for a while. And now it's been codified as to appraisers and home inspectors, just saying that as a matter of law, they're properly classified as independent contractors. That doesn't mean they're always going to be that way. You know, if you had an appraiser who got hired in-house for some company, and, you know, they were no longer kind of out generating their own business and acting independently, they're probably not going to be an independent contractor even with this legislation, but it does clarify that that's going to be the default position. Largely because of that case that you may have heard of before, the Dynamex case, where the court really reevaluated how to do this. A lot of it was prompted by things such as Uber and Lyft and Shipt and all those other services. So this is part of the sort of fallout of this idea of who is an independent contractor, in what industry and why. And so typically, since this has historically been how appraisers and home inspectors and the like have classified themselves, probably not going to see a huge difference in the day-to-day, but it is now been clarified, and there's some certainty as to that classification.
May
Go ahead.
Ask, is the fire disclosure in CAR form already?
You know, that's a good question. I didn't have time to check to see if there was a CAR form for that. Does anybody out there online know if CAR has developed a form for this yet? Because the last time I checked, there was no such form. But it is brand new this year, requirement as of January 1st. So it may be that they've rolled one out now. So I can look while we're talking to see if I see it in my zip forms. But the last time I looked, I did not see a form for it. So I don't know if anyone else has had a different experience or not.
I will look
Um,
right now. I'm looking
yeah.
right now. No form.
Yeah, last time I checked, there was not a car form for it, but there might be now.
When did you check last?
Probably, let's see, I gave a talk on this law sometime in the fall, so it's been a couple months since I've looked.
Okay, I'm gonna check right now.
The law came out in 2020, so like I said, it's not a 2021 law, it's a 2020 law, but this disclosure requirement was a year delayed from the initial enactment of the law. So there was a couple requirements that went into effect last year, but now the disclosure element is sort of fully matured.
Adam, we have one question in regards to the PACE loan. Whose responsibility is it to disclose it? Escrow, agent, listing agent, and how quickly?
So the answer to those is all of them, right? All of them on some level have a responsibility. If you know about it, certainly, right? And certainly the seller's got an obligation to disclose the PACE loan. And certainly the listing agent, if they know about it, has an obligation to disclose that. It should be in the prelim for sure. I would be surprised to not find it in there. And then, yeah, so I guess the answer is, to boil it down, all of the above as soon as possible. Just like any other disclosure. I would treat it just like any other disclosure of material fact.
Makes sense. Anyone else with a question, or are you going to continue on? You got a couple more slides in this space?
Yep, just I think 3 more to go, and then we can do some more Q&A. So I'll just jump back in if I don't have any other questions.
Yeah, please, let's continue.
Okay, so this is a big change in the law. It may not come up for a lot of people. It may not ever come up for you. It just depends on your life circumstances, I suppose. But California has what we call a homestead exemption, and that protects people's primary residence from debt collection. So if they find themselves in financial difficulties, there's this homestead exemption, and it protects a certain amount of equity in their primary residence. And it's meant to do 2 things. Number one, it's meant to make sure folks aren't put out of a house merely because of the debt, and hopefully they're left with some money that they can buy a new house, even if they've had some financial difficulties. And 2, it's to make the primary residence less of a target for debt collection. And I'll explain what I mean by that. Debt collection, like any other legal process, has time and expense associated with it, attorney's fees, costs, overhead. And so unless an asset has a fair amount of value to it, you have to carefully decide whether or not you want to go after it, whether or not there's enough money in the asset to make it worth the time and expense in collecting on it. And in the case of a house, we're talking about putting a lien on it and then ultimately foreclosing upon it to satisfy that lien. So before, the amount of equity that was protected was a maximum of $300,000, but that's been changed to be sort of more fluid, and the maximum amount now protected under the new law is the median sale price in the county, or $600,000. Now, it's whichever is less. So California, or particularly the Bay Area, I should say, being what it is, that it's probably going to be this 600K number is the one that's going to apply, right? Because 600K is going to be less than the median sale price in the county. But think about that. I mean, that's a $600,000 equity protection, $600,000 of stored equity that cannot be accessed by debt collectors under the homestead exemption on your primary residence. So that makes it a lot less attractive for folks to try and go after your property and foreclose on it if you happen to owe money that you're having difficulty paying back. So it's a substantially higher level of protection for persons' primary residence that was not available before. And then it completely eliminates the ability of a debt collector to foreclose on properties, period, for liens based on consumer debts. So those are debts like medical bills, car loans, credit cards, things that are not secured by your real property. So I think especially with COVID, if folks, you know, for example, rack up a bunch of medical bills they're having trouble paying, they're much less likely now to lose their home as a result. So certainly an important protection. One thing I found in there that was important to note for folks like me and for folks like you who are out and about as licensed professionals, you know, doing what we do, is that you're not shielded. The foreclosure portion of it, at least, is not. You're not protected from a successful tort claim. So, like a negligence claim or a breach of fiduciary duty claim. So, if you make a mistake in your business, which happens, and you end up finding yourself in a lawsuit as a result, you know, the $600,000 protection is going to be there for you, but the general protection on foreclosure is not going to help you. So if you've got, you know, $800,000 of equity in your home or something like that, then the creditor could come after you, foreclose on your home, and take the $200,000. So, you know, just a reminder, number one, you know, be really careful, do the best work you can, you know, keep up to date on your risk management and everything else. And then also, you see my note down there, keep your E&O insurance up to date, right? It's super important because these laws aren't going to protect you in the same way that insurance is going to if you find yourself in a tort claim. There's a recent settlement you may have heard about, interesting, the Department of Justice versus the National Association of Realtors. Basically, the DOJ sued the NAR, or brought an investigation against the NAR about anti-competitive practices, and it all circled around the disclosure of the buyer's agent commission to the buyer and to the public in general. I mean, there was a broad complaint, but that's really what the crux of it was. But the DOJ didn't like the, at least what the DOJ perceived to be kind of shroud of uncertainty or lack of disclosure of how buyer's agents get compensated. And they also were really concerned about buyer's agents who would market their services as free, right? Oh, you don't need to pay me anything, you know, it's free. We all understand how and why this is the case, right? Because as we know, as folks experienced in the industry know, buyer's agents are not paid by the buyer. I get a lot of buyers in my office saying, well, I hired my buyer's agent and I'm paying good money. I even had a client once who wanted to sue to get the commission back from their buyer's agent. And you know, it from a legal standpoint, at least, it's difficult because there is no agreement, usually speaking, between the buyer and the buyer's agent. There's no written agreement. It's an agency agreement that just arises out of basically an oral contract. And the payment all comes through the seller, who agrees to pay the listing agent, who in turn agrees to share a part of the commission with the buyer. So technically, it is the seller who's paying all the commissions, even though the buyer may not feel that way, because ultimately it's the buyer's funds that are being used to make the payment, right, on some level, right? Because the buyer is the one funding the escrow and making the purchase. So it's been an area of confusion, I can tell you, for buyers. They don't understand it. They think they're paying the agent, and they're really, in my opinion, and I think technically not. And so it's been kind of an underground type of a system that the DOJ doesn't like. So they went after the NAR for that, and a settlement was reached in November of last year. It's still pending. The rules are not final by any means. The DOJ and the NAR are still working out exactly how this will be implemented and what the rules will be. They have to come to terms on that, and the court has to approve the settlement agreement itself. But it's certainly around the corner, and the rules are going to include something along the lines of these four that we have here, because this is what's in the settlement agreement, right? And so this is kind of the things that we know are going to be coming down the pipe. And one is buyer's agent's compensation is to be publicly available. So that means when you go on sites like Zillow and Redfin, or even on your local MLS website, that field that currently holds that information will now be exposed to the public. So if you run a website that displays listing information, you know, that information is going to be part of the publicly available information that propagates out for folks to look at. So buyers will be able to look at that and see, you know, who's offering to pay what on what properties. It's also going to be a rule imposing a disclosure requirement by the buyer's agent to tell the buyer what they're being paid as far as a commission share on any given property. The third one, you can't market yourself as free, right? Buyer's agents can't go around and telling people that their services are free. They have to tell them that they're receiving a commission and what that percentage is. And then this is the one that I saw. It was almost as though it was snuck in there, because it doesn't seem to be directly relevant to the commission issue, which was certainly the bigger issue in the case. But certainly to me, it seems like almost even more of a game changer, and it could be very difficult to implement, which is that non-MLS agents are to have lockbox access, right? So lockbox access has to be given to non-MLS agents. How they're going to do that, I don't know, because a lot of the technology that the lockbox relies upon is tied very closely to the MLS technology that we all pay for as members. I'm a member of the MLS as well. And it's not cheap, you know, and so now non-MLS agents get lockbox access. This could be, I think, problematic. So it's interesting to see how the rules develop in this regard. Will they have to pay? How much? So on and so forth. And then seller approval, though, is required for that last item to allow non-MLS agents to have access to the box. And then last slide, Proposition 19. I'm sure a lot of you have heard about this one. This was a CARS-backed amendment, and it substantially limits the prior property tax with, we'll call an exemption for parent-child transfers. It used to be that when you transferred a property, that was going to be the personal residence of your child, that they would inherit or take your property tax basis. So if I bought my home in 1960 for $50,000 and I transfer it to my kids, so long as it's going to be they're going to live in it, there was no limit to that, and so even if it was worth 1.5 million today, they are paying property tax on that same 1960 basis. So they take that from me in the parent-child transfer. So that's been basically eliminated, and places a $1 million limit on property to be used as a primary residence, and completely gets rid of the exemption for homes that the child is not going to occupy. So there is no longer any exemption for second homes. Before, the $1 million limit was on second homes, and there was no limit on transfers that the child was going to live in. So that's been sort of flipped around, and the primary residence is now capped at $1 million, and for second homes there is no exemption whatsoever. That's effective. I have February 1 here. That is a typo. Sorry about that. I will fix it before I distribute these. But it's February 15th is the last day, so effective February 16 is when that goes into effect. Effective April 1, and this is sort of the carrot, right? What we just covered was the stick. This is the carrot, which is they've expanded the transfer rules for people who are over 55, victims of wildfire, and the severely disabled. They can take their basis with them. So if you have folks that are retiring and they want to move somewhere else or whatever, they can take their lower property tax basis to their new replacement property. And it can, the rules regarding, used to be you had to pick a property of the same value. Now you can actually transfer it to a more expensive property. And the only part of the property that gets reassessed is the value above that. So just to give you a quick hypothetical, if I'm 57 and I decide I want to move somewhere else, my current home, I bought it for 100 grand. That's my property tax basis in it. It's now worth 1.5 million. If I go buy a home that's worth 1.5 million, then it's an even transfer. I have the exact same property tax basis in my new home. My property taxes remain the same. If I buy something that's 1.7, just the $200,000 is going to get reassessed at current market value. So I'm going to see a slight uptick in my property taxes, but nowhere near the uptick I would see if I were not able to transfer that basis at all, right? So I'm saving a lot of money on my property taxes that way. And it also extends to victims of wildfire and disabled folks. And this can be done up to 3 times. Under the prior law, it was a one-shot deal, one and done. As soon as you did this transfer once, that was it. Now you can do it 3 times, and it's statewide, which it was not before. So it allows before it had to be certain counties who opted into the system, and there were very few, well, not very few, but not many did. And now it's been expanded statewide, and it can be done up to 3 times. So there are some benefits to the law, and then there's some, I think, what other folks might consider negatives to the law as far as the ability to transfer to properties to children. And so that's sort of the net of Proposition 19, which is the other sort of major development in the real estate world this year. And with that, I believe that was my last new law. So I'll leave this slide up here. This has my contact information on it. I'll just leave that up for a second. If you want to email me to get a copy of the slides or any other more detailed information on stuff that we've talked about today, just send me an email and we can work through that. And with that, I will stop sharing. And we have about half an hour left, and we can do some Q&A.
Well. Why, there's a lot going on. Adam, I would like you to address whether or not you believe that the buyer broker agreement may become a standard now that we're dealing with this settlement agreement between DOJ and NAR. I don't know how they're going to manage all of that information and communication in terms of the disclosure of who is earning what. But can you spend just a couple minutes on that and give us your opinion, or what maybe the legal minds are out there talking about?
Yeah, that's a good question. I mean, the buyer broker agreement, first of all, as I think we all know, it's not really commonly used at all, right? These days, and hardly anybody uses it. Some people are like, use it every time and they're super adamant about it, but those people are very few and far between. And interestingly, I'm on the fence a little bit about it myself, because I feel like it hasn't gotten a lot of attention and therefore is not as good as it could be. And, I guess let me state it this way. I'm in favor of a written buyer broker agreement, because as a lawyer and as a real estate lawyer, the number one rule always is, if it's not in writing, it doesn't exist, right? So why not define our relationship with our buyers the way we define our relationship with everybody else in the entire transaction, right? Why is that the one relationship that is not reduced to writing? It doesn't make any sense, right? On the other hand, I think we should be careful, right, in what we conclude in there. Obviously, this is a great place to disclose how we get our compensation and what the seller might be offering us. I'm surprised a little bit that the NAR got so up in arms about the idea of the buyer commission. At least in our area, it's pretty much the same, right? How it doesn't, vary widely. It's between 2 and 3%. 99.99999% of the time, that's going to be the compensation. So I think the buyer broker agreement is a good and easy way to do it, and I think we could do a lot of good things with the buyer broker agreement. But we should also be careful. For example, as somebody who has defended a ton of buyer brokers, more than a small handful of buyer brokers, it's a fiduciary relationship, as you all know. So there's a really high standard of care, right? Which, of course, from a legal standpoint, means that the liability risk is high compared to other relationships that are more arm's length. So we can use that written agreement to sculpt that. But as the buyer's broker, because you're the fiduciary, you are somewhat of a target in, for example, a non-disclosure type of a lawsuit. Why wasn't this discovered? Why didn't you recommend that I get a second home inspection? Why didn't you flag for me this part of the home inspection report that says there's standing water under the home? I thought that was normal. You didn't tell me it wasn't, right? As bogus as some of these claims are, that's what you get, because that's the fiduciary relationship, right? The fiduciary relationship goes beyond mere delivery of information and dips into a more active type of a role. Where am I going with all this? If you look at the listing agreement, if you look at the contract, most of these documents have, for example, an attorney's fees clause in it. Query whether or not you would want that in a buyer broker agreement. And as I understand it, the last time I looked at the buyer broker agreement, the car one, it also had an attorney's fees clause in there. I don't know that I like the idea of an attorney's fees clause in a buyer broker agreement, because from my standpoint and experience, I think that makes the buyer's broker even more of a target in a lawsuit, right? Because now, if I'm the plaintiff's attorney, that's a pretty juicy target. Not only are they a fiduciary, but I've also got a vehicle for fee recovery. Right now, one of the ways, and I can tell you from practical experience, one of the ways cases settle is that when a buyer sues, and it's typically the buyer who sues, right, as you all know, they typically sue everybody, seller, home inspector, pest inspector, listing agent, buyer's agent. There's typically no attorney's fees recovery against either of the brokers, right? There's no fee recovery against the listing broker because I don't have any contract with that person. And there's no fee recovery against the buyer's agent because I don't have any written agreement for that with that person, right? And absent a written agreement for fees, there is no fee recovery. That's what's called the American rule, right? So sometimes the existence of a fee provision like that drives lawsuits. This is very much true in the landlord-tenant arena, and it's very much true in the employment arena, right? Where you hear employment attorneys or landlord-tenant attorneys saying, I don't care. Maybe I win, but maybe I only win $10 instead of the 100,000 that I'm asking for, but I'm going to win. And when I do, you get to pay me my fees, so go pound sand, right? It drives litigation because it creates an expectation of fee recovery on behalf of the attorney filing the claim. So there's an incentive almost to bring a lawsuit where you have that. And that's just one example. I know that's a long answer to your question, Hilda, but it's to say that I would be happy to see wider use of written agreements in between buyers and their brokers. But I think we need to be careful about what we put in there to make sure that we're not setting ourselves up for, making ourselves a target or creating another vulnerability for ourselves. But otherwise, I think it's a great place to do that disclosure. And I think it's a great place to sculpt our relationship, right? Narrow that fiduciary duty potentially, saying, hey, this is what I'm going to do. This is what I'm not going to do. I'm not going to go to the county and check permits unless there's something in writing that says that I'm going to do that for you, which I would never do. That's not part of our relationship. I'm not going to go, this, that, and the other thing. So you can feasibly sculpt somewhat your relationship with your buyer by using that agreement. And that is the positive of the written buyer broker agreement, is that you have more control over what is a relatively broad and amorphous fiduciary duty by saying, this is what I'm going to do for you, and you, the buyer, understand that, and you're signing that, and you get it, and you know that I'm not going to do certain things, and then I'm committing to do certain things, and so on.
Adam?
I have a question.
Sure.
Adam, so my question relating to the tenant relationship after close of escrow. Let's just say that we have a tenant that's not on a fixed term lease, and after the close of escrow, they refuse to move out due to the COVID situation. What is the remedy? What can the owner do to remove those tenants?
Nothing. Nothing. Nothing.
What is
Was that Raymond? Is that your question?
Yes, I am.
got you guys on. Okay. So the answer is, in typical lawyer fashion, it depends, right? It depends on what the usage of the property by the buyer is going to be. For example, if the buyer is not intending to occupy the property, then the buyer's options may be 0 to none, right? You're probably not going to do anything. Now, if you are planning on living in it as your primary residence, there's definitely options that you have, right? You can do an owner move-in eviction. You're going to have to pay some relocation expense, and you're going to have that residency requirement we were talking about before. But that's really the key component. The key piece of information is the buyer going to live there or not? And like I said, the courts have caught on to the use of an owner move-in eviction to remove a tenant when the owner does not intend to live there. So, if you've got a client who's kind of giving signals that this is what they're planning on doing, look out, because it's probably not going to work out. I mean, it's that sort of ship has sailed, right? The ability to sort of obfuscate the owner move-in is really tenants are aware of it, right? The courts are aware of it. Courts don't like these owner move-in evictions. So if the tenant comes in and says things that are counter to your stated intent to do an owner move-in eviction, the court's more likely to believe the tenant than you. It's just the reality of the environment. Not to mention the fact that California courts are tenant friendly anyway. So anyway, I can't caution strongly enough against being very careful with owner move-in evictions. They're absolutely appropriate. They're absolutely legal, but you just really have to live there, right? That's really all there is to it. You really
But,
gotta genuinely want to live there.
But as a practical matter, if the court is not open due to the COVID, and they're not hearing the eviction cases, even with the owner-occupied type of evictions, what do you do?
Well, right now the courts are. So right now the courts are hearing evictions. I've done a few over the last few months. We've gotten a few tenants out. We even got one tenant out earlier on when the courts were still largely closed, and it was because there was a public health and safety threat presented by the tenant. The tenant had, sadly, on some level, the tenant who had historically been actually an okay tenant found himself on the wrong end of a drug and alcohol problem and sort of derailed. And it was I think a triplex or a quadplex, and so he was doing a lot of things that were presenting a substantial risk of safety, to the other tenants. And so we were able to get that tenant out. But it was not easy, right? It was not easy. And so we had to convince the court of that, which we were able to do because we had police reports and all that stuff. But then, as luck would have it, we got a court order. The judge signed an eviction order saying, yeah, get this person out of here. And we took it down to the sheriff's department. And the sheriff said, you know what? Our understanding is that there's no evictions happening right now. So we appreciate that you have this order signed by a judge, but we're not going to enforce it. And my eyes almost popped out of my head. I said, what? It's a signed court order. I do respect, sir, but I don't know that you have an option. And to which I got the reply of, well, I'm not going to do it. And so that's where we left. So the client, upon receipt of this information, had the presence of mind to get very angry and call her county supervisor. And the supervisor's office actually called into the sheriff's department and told the sheriff, look, you've got to talk to your civil department. They've got to enforce this order. It's signed by the court. It's just, you can't just pick and choose. And so we got it done. But I mean, it was, it's always difficult. It's not like that anymore. Things have changed, and we are able to more smoothly process evictions. We had an eviction trial that was set for trial last Friday, and we settled it. We showed up at the pre-trial hearing, and then we were able to work out an agreement with the tenant. But that would have gone to trial starting yesterday if we hadn't been able to settle it. So the court is open for eviction.
Okay, thank you.
Go ahead, Sheila. I see your hand up.
Okay, I have two questions. The first one has to do with a zero fee to the seller as a commission structure written into the contract if X price is achieved by the seller, which exceeds their expectation. Is that a legal remedy to having the right to say zero fee to the seller, knowing that you're using your fiduciary responsibility to say, I believe I'm going to get way over because there's crazy bidding wars going on. And if I get you 100,000 over, will you agree to not, will you agree to allow me to have a zero commission and earn something more than a commission?
Well,
I'm not sure I completely understand the arrangement. Is it like, hey seller, I'll be your listing agent, and unless I get $2 million from the property, you don't have to pay me? Is that the proposal, or
some number? Yeah, let's say he's expecting 1.5 and you get 1.7. Okay,
Mhm.
or 1.5. You set a number, so you're not really just open-ended and just trying to take advantage. But if you see people overpaying, probably, and he's willing to take the chance of saying, you know what, I'll take the risk because I'm not sure that property is going to get higher. And I'm willing to say, I will take a lower commission with the understanding that I could potentially get a higher price for your sale. And I want to share in that as a way of getting compensated.
I mean, I guess off the cuff, with the caveat that I would want to, take some time to read through whatever the final agreement looks like. Commissions are negotiable, and I don't hear anything per se illegal in that. It's to me, it's. Oh, I think my internet connection is breaking up here.
I can hear you okay. It looks like Adam is frozen.
I just actually saw somebody, it was a presentation and just said zero commission.
There he goes.
Am I back?
Yeah, you're back.
Okay, good. Yeah, so what I was going to say is it's kind of analogous to the situation where you got a dual variable commission, right? Where you say, hey, look, if I end up, you'll pay me 5% and I'll share 2% with the buyer. But if I bring the buyer, then I'd be willing to accept 4%, right? So I'll save you a percentage point. I'm still getting a little bit more. You're paying a little bit less. Everybody's happy, kind of a thing. I don't see it being any different than that. So I don't. Again, I'd want to take a look at it, but I don't. As long as you're not charging an advanced fee or anything like that, you're just negotiating the percentage.
Yeah, because I saw that come across where the advertisement was zero fee, and I thought, oh, I know the trick. They're gonna convince the people that their house is worth X or Y, and then pocket some percentage over that X or Y number. So that's one thing, and
And I would be comfortable with advertising as zero fee, because even if we have a relationship that you're talking about, Sheila, where there's sort of a variable, or even if I don't get a certain amount, maybe I get nothing. That's still not, in my opinion, a zero fee relationship, right? It's a zero fee if relationship, right? But it's not. Yeah, I would be, the agreement itself, I'm okay with as a negotiated commission, but the advertising, I think the BRE would have issues with.
I saw that just recently, and I figured I'd bring that up. The question you had before is about over 55, you carry your tax base 3 times to another place, but then you said, let's say you sell it for 1.5 and you go to another place for 1.5, then you have the same tax base based on the sale price of the existing property?
Your same property tax base, right? So
carrying your tax base to the new property in another area, and you're paying equal or less than the 1.5 that you just sold it for?
You're paying in that circumstance, right? That's the benefit of it. And that was part of the law before. So this law has already existed in California in a more limited fashion. And that's one of the ways that Prop 19 was promoted, was by expanding this benefit for folks over the age of 55, which is that if you had a house and let's say you bought it for $100,000, that would be your property tax basis. Now it would be adjusted upward at about 2 to 3% per year to the current day. So it's not going to be 100,000 anymore. Let's say today it's like 275,000, right? But it's still much lower than the property's market value. Let's say the market value of the property is $1.5 million, right? So my property is worth $1.5 million, but I'm paying property tax on $275,000. Under the law, if I am over the age of 55, I can sell that property, and then I have to buy my replacement property within 2 years. And if the value is the same, if I pay 1.5 for the new one, then it's just a clean, pure transfer, and I continue to pay property taxes on that 275, which again will continue to get increased by 2 to 3% per year, just as if I hadn't moved at all. As if I hadn't moved at all.
So you had the number 1 million. You had the number 1 million in your example, and that threw me off.
Right. Well, that would be because there's a difference between obviously your assessed value and your market value, right? So that's Prop 13, right? That's what Prop 13 did back in the 1970s. So that's why, for example, this happens all the time in the peninsula in particular, right? You've got folks who bought properties in Palo Alto in the 1950s for $45,000-$50,000 bucks, right? And now they're worth $4 million, right? So if you had to pay property tax on the $4 million bucks, you'd be paying, what's 1% of 4 million? It's like $40,000 a year, right, in property tax. But instead, you know, you're paying property tax on the original purchase price plus inflation over the years. So it's, you know, maybe a couple $100,000. That's your property tax basis, and that's what you can transfer to a replacement property if you're over the age of 55. And it's specifically designed to allow people who are over the age of 55, folks who are looking at retirement, to keep their property taxes low, but still allow them to move to a no home if they want. And so if your property tax basis goes with you, so that even though you're paying much more for your house, right, because you're paying market value for this new property, you're paying your same low property taxes.
So that's going to be a big problem for any county having to accept these low tax-based transfers.
That was the resistance. That's why under the old system, there was only a limited number of counties who had sort of opted into this system, right? Because again, this existed before, but it was a one-time only deal, and only if the county was participating in the program. Now it's statewide, and you can do it up to 3 times. So it's going to probably encourage retired folks to move more often, or at least consider moving more often, which could be a good thing. Certainly a good thing for sales volume, right?
Yeah, but
so
counties.
Not for the counties, yeah, necessarily, yeah. So, but then again, that, like I said, that was the carrot, and then there was also the stick, and the stick was the elimination of the parent-child transfer. So that's going to cause a lot of properties to get reassessed. So it's kind of like, what am I looking for? It's, you're robbing Peter to pay Paul on some level, right? You're taking something away from that's typically been a function of inheritance, right? Normally when I inherit my parents' property, I inherit their property tax basis along with it. That's gone, right? Unless I'm planning on living there. So, you know, it's,
Could a
there's,
10-year-old child be the person who's going to live in it and then take their parents with them? Or
that's a good question.
you know,
I don't have an answer to that one off the top of my head, but the law just says child is going to make it their primary residence. So I think,
and they're going to have a caretaker.
argument could be made,
Yeah.
right? I would think that probably would qualify if they are making it their primary residence. Yeah.
I think so too.
Adam,
Grandchildren will inherit it.
Adam, so regarding this question, I called BOE and they actually called me back because I have this case. One of my client purchased a property, will close in February, and he's planning to sell his property later. So as long as one transaction in after April 1st should be okay. And regarding the value, I clarified with BOE person called me back. He said the value is the property, we say the old property was 2 million, and then he buy the property that is 3 million. And there is $1 million appreciation.
Right.
So there's $1 million appreciation will add on top of the $2 million house's assessment. That is the new property tax basis.
That's right. That's correct. That's why my example used 2 properties of the same market value, right? Because then you have a clean transfer, the values line up. This is a new feature of the law, which you've just described, Stacy, is part of this new law. You were not allowed to do this before, but now you can buy, as you've described, a more expensive property and still retain some benefit of that transfer. So that if my original property was worth 2 million, like you said, I'm going to retain the tax basis as to that 2 million. And if I buy a property, as you've described, for 3 million, the only part that's going to get reassessed is that $1 million difference. So I'm going to pay my old property taxes plus taxes on $1 million, which would be about $10,000 a year, right? And so, yeah, it only is reassessed to the extent that the value exceeds the original property's value.
Wait a
If they're
minute.
the same, there's no change. If it exceeds, the replacement property is more expensive. You only get taxed on, well, you only get reassessed on the additional value. Much the same way if you were to remodel that same house. Let's say I own a house that's worth $2 million and I do a substantial remodel and increase its value to 3 million, I'm potentially going to get reassessed on that million, but not on the original 2 million.
If you're over 55 or over.
55 or over, correct. Or a wildfire victim or severely disabled.
So I should buy my son's house when he builds his $4 million house and bring my tax base to it, and I become the owner of his house.
Right, but you're going to get reassessed on any difference in value.
Between mine
if-
and his will only be $1 million, let's say, whatever the number. But that's the way to do
Correct.
it. Okay.
I mean, it depends on what you do it for, yeah, but that could be a strategy, yeah.
But another question is interfamily, right? This interfamily transaction is not is it not considering arm length, right? Will that still qualify?
That's good. Because it's between family. It's good.
Well, the parent-child exemption has been eliminated by the new law, so it's not, I mean, it used to be you could just give your son the property and they would automatically inherit your tax basis by virtue of you gifting them the property. If they were going to use it as their principal residence, that exemption was unlimited. If not, it was limited to $1 million in assessed value, right? Note the word assessed value, not market value, in assessed value. That part of the law has been completely redone, and it's been replaced with a very limited exemption of $1 million only for personal residences and no exemption whatsoever for second home.
Horrible. Horrible. I'm going on the record. That's not a good deal for investors. It's
I'm
not
going to take this. I'm going to take the fifth because it was sponsored by the CAR. So I'm not going to go on record one way or the other. I'm just here to describe what is.
There was such a marginal win, right? 1%. And now we get all this backlash. Now everybody's saying all they did was read, the first 2 lines. It was going to help fire victims and it was going to move real estate. And they didn't know what the
Snuck it in. They snuck it in.
Yeah, the trade-offs are big, 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 big. And there's not much you can do if you get past that February 15th date. So go see your estate attorneys and figure out what you're going to do in the long run, because it's an expensive trade-off.
I have a question, Adam.
Go ahead, Sundar.
Can I go?
Yep, go ahead. Yep.
Yeah. If I don't have a broker's new buyer's agent agreement and I'm continuously showing for the property to that client 3 or 4 months, and I have wrote 4 or 5 offers for him, later the buyer bought a property with the other agent. Because of the P document that I've sent him over and over to show 20-30 properties, is there any way I can go after the buyer to get my full broker fees or compensation?
I would say as to the buyer, probably not. That's one of the advantages of having the written buyer broker agreement. Typically, in your circumstances, what I see is what we call a problem of procuring cause, and it usually involves a claim by someone in your position against the seller or the listing agent for sort of cutting you out of the deal. But as to your buyer, because you're in a voluntary agency, which means that either of you could say sayonara at any given time and you're gone, it's done. See you later, hit the road, right? Because you've got no guarantee of your continued employment, right? It's completely voluntary arrangement. So that is one of the things that the buyer's broker's agreement does that could be a very positive thing, much like the listing agreement does, exactly, right? Where the listing agreement says, hey, look, if I introduce you to a property and or to a buyer and they make an offer within X certain amount of time or with X number of days after the expiry of this agreement or whatever, right? There's definitions as to what's going to happen and how this agreement's going to get terminated and when, and so on and so forth. But without a written agreement, you don't have any of those protections. So that is a good example of how a buyer's broker agreement could be very helpful to buyer's agents.
I got a question follow up with your answer. If for the same home, you show the property signed a P, but they write offer with this other agent, that's not a procuring cost for this one either, right?
It is. It is a procuring clause.
There's no buyer agreement, but you signed a P with this property, but this wrote offer with someone else. Yeah. Do you have any base to ask some money from buyer side?
I mean, it's going to depend on the facts and circumstances, but it's going to be a tough battle because you don't have a written agreement with that person. Now, procuring cause doesn't necessarily require a written agreement to make the argument, but I'm just saying that in the relationship between the buyer and the buyer's agent, it's a more difficult argument to make than
to add something on your answer. For this buyer, I do have a kind of buyer agreement, but it's not a car form. It's some like a homemade form. Do not list what if a buyer violated the contract, what they should do.
Hey, true.
Is there something? Is there anything
I
for
can't
this
believe it.
commuter property? You can ask them money.
I mean, I would have to see what your agreement says. You don't need to use car form. Certainly, if there is the car form is, they've been vetted and they're usually pretty good, but you can certainly make your own buyer's agreement. And I've seen other brokerages, I won't say a lot, but I have seen other brokerages who do have their own in-house buyer broker agreements. I'm trying to think of an example, but I've seen it a couple times where an individual broker will take this on and say, look, this is a good idea. And so they'll have kind of an in-house form that they'll use. So it doesn't have to be the car form, and it can be really simple or it can be really complicated. But the terms of whatever you put in there, you're going to want to make sure that you've got specificity as to how you, as the buyer's broker, perfect your right to compensation. For example, if I do A, B, and C, you agree that I'm going to get paid, right? And if I don't get compensated by the seller, or if you cut me out, or if you fire me, you're still going to pay me, right? So that's the whole purpose of that part of the agreement.
The agreement said the client will use the best effort to protect broker in the receipt of its compensation, but it doesn't hold clients accountable for my commission. So I don't know if there's because this is a whole, so even we have this written agreement with the PED for this particular property, which is still not get any paid.
You have to have a.
Yeah, I mean, I'd have to spend some time looking at your agreement and going through the facts and circumstances in order to give you an opinion as to whether or not I think you have an enforceable claim to a commission. There's just no, I can't in good faith give you a full opinion in this format. It's going to depend on both the content of the entire agreement and whether or not we can establish there was a breach of that agreement in some fashion, and then also the facts and circumstances surrounding the termination. For example, and I'm not saying this is true in your case, but the buyer may have a counter argument which says, look, I had good reason to terminate our agreement, and here's why. And so it's not as simple. It's not as simple of an analysis as like, yeah, okay, the agreement says that the buyer's going to look out for the interest of the buyer's broker, therefore you should get paid, right? There's more factors than that.
Adam, I have a question. I have an off-market property that I work co-list with the other brokerage, the other agent. I partner with her, and so we have not put this property on the market, and then we receive an offer, and then the seller said, no, I'm not gonna entertain that offer. I want to put it on the market. So I tell the agent, I said, we're gonna put it on the market. We're not gonna taking your off market. We're not gonna take your preemptive offer. Then she said, well, if you put on the market, we may not make an offer. That offer actually is reasonable on the market price. And then I said, well, that's up to you. I said, if it does not sell, it does not sell. It's up to you. And then about 10 days, I did not hear from this agent. During this 10 days, the other agent I partner with, and she brought in an offer which is higher than her offer before last year. And then the seller accepted. And then 2 days after we get in contract, this agent come back and say, well, my my client is willing to make a higher offer, which is much higher than what we get into the contract. Then when she said, oh, well, they're willing to make a higher offer, I said, no, just hold on to it. Let me ask my partner, because I know there's an offer in. I have to see if it's signed. And then she just, without any communication, just boom, sent an email to me, which is really high, which is actually 200K more. And then I said, sorry, we already get in contract. And then she said, that's okay. Well, my buyer requested to have a seller to send a rejection. I said, what rejection about? It's this property is already sold 2 days ago. It's not available anymore. Why do I have to reject? And I was really upset because if I bring this really high offer to the seller, and seller will get really upset. And that price, which is really ridiculous high, be honest. And do I need to concern about any issue here? Because it's off the market. We have not put it on MLS listings.
Did it ever get on? I thought you said it was on the market for like 10 days, right?
No,
like
we
that?
did not put it on the market. No.
Okay. I mean, if you've got a deal, you've got a deal, right? So, there's got to be some other reason to breach the contract or to terminate the contract. If the seller's going to terminate, they can't just terminate because they've now gotten a later, better offer. I think that from your perspective as the agent, I mean, I don't know that you have much choice but to share that information with your seller, because that's the seller's right. And, that's the decision the seller made. The seller made an offer or accepted an offer, and that's that, so, it is what it is. I mean, maybe you could take them in backup position. I don't know. But yeah, you're kind of stuck.
Yeah, would that be any legal concern about? Because if I tell seller, and seller obviously get really upset at me and said that can be that really high offer, but it's already in the contract. Maybe the seller want to back out and cause a lot more issues, maybe legal issues and stuff.
Yeah. I mean, the seller may or may not get mad, but it is what it is. I don't think you have any choice. You've got a duty to communicate all offers to the seller. This offer is late, but I'm not aware of anything that would preclude you from fully sharing with the seller.
Do I need to represent it to seller and having the seller to reject that offer? The late.
There's nothing to reject. Or accept the seller's already sold the property, right? If you're in contract already, the property is done, right?
Yeah.
So I don't know there's no such thing as a seller rejection, really. It's just the seller doesn't sign it, right? And the seller can't sign it because they're already in contract on the property. So there's an offer doesn't need to be rejected. And so if the other agent is saying, well, I want an affirmative rejection from your seller, you can tell the other agent, go pound sand. You're not entitled to an affirmative rejection from my seller. Because there's no, an offer is just an offer, right? Anybody can make an offer, but the seller's not obligated to sign it or reject it or whatever they want to do with it is what the seller wants to do with it, right? But they don't have to affirmatively reject that offer.
Got it. Thank you very much.
Adam, can HOA block a junior ADU?
I heard something followed by junior ADU.
Can an HOA block you converting a garage in an association as a junior ADU?
This is a good question. I'm going to give you an answer with a big disclaimer. I would need to see the governing documents. I would need to know more about the history of the particular planning process for the junior ADU involved, and whether or not, for example, the appropriate procedures have been followed by the homeowner in applying both to the city or county, as it may be, and to the HOA. But the very short answer is probably not. Probably they cannot prevent you from building that because state law mandates the right to build up to 2 ADUs in a lot of areas on the property. So cities and HOAs and counties are incredibly limited in what they can do nowadays with the new law to prevent somebody from building an ADU. It's a very much ministerial process. So my answer to you is I think that they would probably be outside of the scope of their power doing that. I would just need to know more about the context because, for example, maybe the homeowner screwed up and didn't submit the right materials, and so they're rejecting the application, but they're not really saying, no, you can't build an ADU. They're just being a pain in the you-know-what to make the homeowner jump through the hoops in order to get it done, which would not surprise me in any way. But no, I had this issue come up in a case about a year ago, and again, the net of it was that, look, that the HOA really is not empowered to override state law and preclude the construction of the ADU.
Thank you.
Adam, I have a question. This is Harvey Young, and the question is going back to Proposition 19. Basically, if there's a couple that get married, let's say the husband is older, he's over 55, but the wife is not. They go and buy a house, and they both have houses, by the way. So the husband sells his house. It has a lower property tax than what is going to be going towards the new house. So he can apply that to the house. Now, when the wife turns 55, and let's say she sells her house because she has a house and it's lower than what they already have, can they do anything about, can they use that one? They're married.
So there's a couple levels, I guess, of analysis there. First of all, as I understand it, interspousal transfers are not affected by Proposition 19. So there are still special exemptions from assessment that exist for interspousal transfers. I also understand that you can transfer, and I've assisted clients in so doing, partial interest. And so the situation that you are talking about is a hybrid of the two. And you can transfer, assuming you qualify for the transfer of your tax basis, you can transfer a partial interest, but only so long as those interests line up, right? So if you're transferring half of an interest in property A and acquiring half of an interest in property B, you basically you treat the two halves as a house, right? So it's the same analysis as the regular 55 plus transfer of property basis. You're just applying it to the half of the house you're selling and the half of the house you're acquiring, right? But the partial interests have to line up for that to work out. If you sell half a house and buy a whole house, it's less clear that is going to qualify for the exemptions provided for by the law.
Can you hear me?
Yeah, I see you, Sherry.
Oh, okay. Thank you so much for your time. This has just been wonderful.
Of
Quick
course.
question. I inherited a property from my mom and dad 6 years ago, and I obviously got their the tax base transferred. Will this new law be retroactive, do you think? My CPA said it might be.
No.
Okay.
No.
And then my
No,
second.
and that's why if you Google Proposition 19, you're going to get a bunch of lawyers like myself advertising their services to get these transfers done before February 15th, because everyone wants to get these done before the law changes, which is February 15th.
So my other quick question, one of your slides said that the expiration of a lease is not a just cause eviction, but if the lease included the just cause disclosure and it's a condominium, so it's excluded, would the expiration of the lease be a reason? Could the owner not renew it?
Yes, in that circumstance, assuming you're exempt from AB 1482, which a condominium is a single family property under the law, right? Under the test for exemption. So assuming it's a condominium and you just own it, it's not owned by a corporation or a real estate investment trust, so it qualifies for the exemption and you've given notice, timely notice, I should say, of the exemption, which means it was either in the lease when they rented the property or it was delivered by mail prior to the end of August 2020, then you have perfected the exemption, so the law doesn't apply to you. So then what applies is state law as it was before. And yes, under state law as it was before, the expiry of a fixed term lease is certainly basis for an eviction, and actually there's no notice required unless the lease itself requires notice.
Okay, so what happened was these folks were in the condominium for quite some time and the owner let them go month to month. And then the owner decided that he wanted more control. So I rewrote a new lease, which was for 6 months, including the just cause. And now we're coming towards the end of the 6-month lease, and the owner has decided that he might want to move in or do a substantial remodel. So he would be okay.
Yes. So one thing to put a pin in though, keep in mind that AB 3088, which went into effect in August, extended the protections of just cause to even exempt properties. So right now, today, you could not remove that person because of the expiry of the fixed term lease. Now that's supposed to expire come the end of the month. And so come February, you shouldn't have any problems. But remember my for now reference, right? Keep an eye on any extensions to that. If they extend that, then you're going to have to be you're going to have to wait until those extensions expire, because right now the exemptions have basically it sounds to me like you have perfected the exemption appropriately, and so that you are exempt, or I should say the property is exempt. You're not exempt. The property is exempt, but because of these special rules, you're going to have to wait and see if they're extended. If they're not extended, then you're okay. If they are extended, then you're going to need to wait for those extensions to lapse.
And then lastly, I'm going to refer give your name and all your contact information to my broker to have you come do this at one of our meetings.
Great. Absolutely. I'd love it.
Thank you.
Adam, I have a quick question. So for Prop 19, let's say if your parents transfer you the property now before the 19th, does the tax change? Or you keep the same taxes that your parents currently have?
It depends on whether or not it's a property that you are going to be occupying. But right now, if your parents were to transfer you real property in the state of California, it would be under the existing law, which provides an exemption for parent-child transfers. And that exemption is without limit if the property is going to be your primary residence, and then it is limited to $1 million in assessed value if it is a second home, you know, being an investment home or any property that you're not going to occupy as your primary residence.
But if I stay on the property, then I keep the same taxes that my parents have, up to $1 million. Is that what you're saying?
Up to $1 million under current law if it's a second home. No limit if it's going to be your primary residence.
Okay, and the other question is, what if there's two children that they want to pass down the property to? Do both of us have to be at the same property? Or one of us has to be the primary property residence?
So it could depend on who's going to do what with the property, right? So you may be treated differently than your sibling, and this is a partial interest in that case. So your half, if you're going to be living there, may be subject to different amounts of exemption or no limit potentially under the current law if you're going to be living there. Whereas your siblings' share, whatever percentage that is, might be treated differently if they are not going to be living there, right? So you'll each be treated on some level separately for your individual interest in the property, right? And I'm assuming there'd probably be 50-50 or whatever, but that's not always necessarily true. Sometimes it's the 70-30, sometimes it's 60-40, sometimes it's 90-10 if your parents really don't like you that much. You know, it just depends on what they give everybody, you know? So it's a question that your parents are going to want to see their estate planning attorney and find out what makes sense, both from the standpoint of property tax and income tax, right? Because a lot of people are freaked out about the property tax thing, but there's also lots of other considerations to be made, and very important ones, particularly in the areas of estate planning and income taxation, because those are federal laws, and the income tax provisions are not necessarily changing with Prop 19. Well, they're not changing with Prop 19. Prop 19 has nothing to do with those. And so you may not want to make that decision just because you're thinking, oh my gosh, you know, property tax, we want to get this done. It may not make any sense because you may lose huge income tax advantages just to save some money on property tax. And that may or may not be worthwhile to either your parents or you, depending on what your estate plan looks like and what the property can be used for. Does that make sense?
Yeah, that
So
makes sense.
you need to check in with the estate planning attorney or CPA or whoever's handling that issue to make sure that, I mean, because if we just look at it just from a property tax standpoint, yeah, okay, it makes sense. Let's do the transfer now and avoid this new law. But there's a lot more to be considered. And frankly, time is running quite short on these considerations. Yeah.
Thank you.
So Adam, staying on the same subject, so there is the property tax base and income tax base. That is definitely the challenge. And then there's also the limitations on gifts for estate planning, right? And there's rumors that those will be reduced in the near future as well because of, you know, we're going to have to pay for all of this pandemic. But I also had a question. What about doing a 1031 exchange in the future? Say you opt to get the gift and, you know, surrender or forfeit the income tax savings. What if you did a 1031 exchange, provided that's still available to do in the next few years too? Has there been any talk about that in the legal field?
You know, with the caveat that I don't practice income tax, so I don't spend a lot of time looking at it, although I obviously do deal a lot, at least tangentially, with 1031 exchanges and things like that. So there may be, I just don't watch that industry as close. I do the real estate side of it, the property tax stuff. But as far as the 1031 goes, it's a deferred tax device, right? So you can only use it for investment properties. And a lot of clients don't understand this. They think, oh, well, I'm going to 1031 my house. That way I don't have to pay capital gains, you know, when I buy my retirement home. And the answer to that is no, that's not. You can only exchange investment for investment, and it only defers the payment of capital gains to at some future date when you actually sell the property in a regular transaction. So it's just a tax deferral device. So that may be helpful. To go back to the last question, that's certainly something to be explored. That maybe a 1031 in combination with a transfer now would make sense. But you know, that tax question is going to need to be answered by somebody who frankly is expert in income taxation.
Okay, Yolanda, I think we'll be shutting it down after that if in terms of questions. So Yolanda,
Thank you. Thank you. I just have a question.
Sure.
With child parent purchase of a home, what if that child passes away? Does that eliminate the widow with the taxes, the increase? So for example, my husband passed away 3.5 years ago, and we bought the house from his parents. So we were on that proposition. I forgot which one it was back then, because this was like 12 years ago. But
sure.
Does that proposition, since he passed, do I still get can my taxes go up? I guess is what the question is.
So as I understand it, if I can restate it, you and your husband purchased a property from your husband's parents, and in so doing, you inherited your husband's parents' property tax basis. And
Correct.
Now your husband has died, and you're wondering if that's going to have an impact on your property tax basis. Do I have that correct?
Correct.
I think the best answer is probably not. I would see not. I think that's going to be covered by the spousal exemptions. And were you guys holding title as joint tenants?
Yes.
And that's probably going to play a role too. So I wouldn't think so. And your husband died 3.5 years ago?
Uh-huh.
Yeah. And so your husband died 3.5 years ago. Yeah, I'm assuming the county hasn't sent you a letter saying, so sorry to hear about your husband. Here's a big property tax bill, right? Otherwise, you probably would have been calling
Well,
me.
my taxes did go up. That's, yeah, no, well, my taxes did go up. That's why I was kind of concerned.
Well, they're gonna go up. How much did they go up?
I don't recall.
Because they go up every year a certain amount, so it's not fixed. Your property tax basis doesn't stay the same over time. It does go up over time, just a minimal amount. Well, I say minimal. It's not. It's about 3%, but every year. So it's going to go up. It's just a question of whether or not there was a reassessment of your husband's interest when he died. In my opinion, there should not have been, and if there was, I think you could challenge that, and there's ways we can appeal that. If your husband died 3.5 years ago, it depends on when the reassessment happened. You're going to want to obviously do this sooner rather than later, because as the time goes by, you lose the right to appeal, stuff that's happened too far ago in the past. So if you've been reassessed, you're going to want to have somebody look at the property tax history and verify whether or not there's been a reassessment. If not, then there's nothing for you to do. You're fine. If there has been, then you could potentially appeal that, and maybe you can get a refund for some of the years where you were overcharged.
Oh, thank you so much.
Mm-hmm.
Okay, I think
All right.
Adam has been more than generous with his time. So Adam, thank you very much.
Thank you.
On behalf of our community here, we're very grateful for your time. Adam, do you happen to have a newsletter that maybe some folks could subscribe to? Do you publish anything regularly when there's changes to forms or contracts or anything like that?
We do. We have a blog and a newsletter that we put out on a fairly regular basis. I'm going to, let's see here.
You know what? Don't worry about it. Send me the slides and I'll send it out.
Okay.
And send me that link, and your blog is very
Perfect.
good. Also on their website and their blog, they have a series of other attorneys that they have either collaborated with or have confidence in. It's a great resource for current information on real estate trends. And also if you're looking for a referral out for another area or specialty. And I just find it to be extremely resourceful. So thank you, Adam, very, very much. We really appreciate you and wish you and yours nothing but the best in 2021. And hopefully we will have an opportunity to work together in the most positive sense.
Absolutely. Absolutely. Yeah, no, I always like when people see us during their transactions, when we can get down to things and hopefully correct issues before they become issues. So, as they say, an ounce of prevention is worth whatever the other part of that phrase is.
I agree 100%. Don't wait until the bottom falls out. Get ahead of it.
Absolutely. Yep.
Williams, one of our bold laws, it's win-win or no deal. So that's the way.
That's right.
Everything. Thank you again.
Well, thank you guys
for joining us. Yes.
Thank you so much.
I appreciate it. Thank you. Have a good day. Bye.
You too. Bye.
Great. That was great.
Thank you, Hilda.
You're welcome. Take care, everybody.
You were great.
Thank you, Hilda. It was great.
I hope you
Thank you, Hilda. This is Gina.
So good. Thank you, Hilda. Thank you.
Thank you, Hilda.
Take care. My pleasure.
Good to see you, Hilda. Gina here.
Yeah, good to see you too, my dear. Where's your face? We're gonna have to do FaceTime.
Yes, ma'am. Have a great day.
You too. Bye now. Hi, Rhonda.
Bye, everyone.
Bye.
Bye. Bye, Sheila.
Thank you.
You're welcome.
Thank you, Hilda.
You're very welcome, Aha. Nice to hear from you. Miss you.
No, I miss everybody too.
You are on fire, my dear. How did your new development go? The price sold already.
Now we're still working on the disclosures, and everybody wants to put offers in. So hopefully, yes, I'm putting the disclosure end of the week. So
good. Okay, let us know of that opportunity. Soon it comes to market. We're ready to go.
It is on the market.
Oh, it is? Okay, it's open now. Okay.
It is. Lupita did a nice job on an ad, and she got a lot of leads.
Very good. See,
Yeah,
everybody.
it's all over the MLS. It's under Douglas. Just search Douglas Place.
Douglas Place?
6 homes, 401, 407, yeah.
Everyone should do that. It's a great opportunity to run.
Yeah, I
Facebook.
told everyone. Yeah,
Perfect.
really cool. Yep.